History of the Harmonized Sales Tax, or HST, in Canada. Now, in Canada, the Goods and Services Tax had been introduced by the federal government on January 1st, 1981. Nonetheless, support for the introduction of the Goods and Services Tax, also known as the GST, was far from unanimous. The tax's unpopularity, which may be explained in part by its sudden visibility compared to the former federal sales tax, and the fact that it was introduced during hard economic times, made it a prime target for the opposition parties. In early 1991, the provinces appeared to be less reluctant to harmonize their respective sales taxes with the GST, or Goods and Services Tax. Some implied they might be on the verge of reaching an agreement with Ottawa. In February of 1991, the Saskatchewan government said it would harmonize its sales tax with the GST starting in 1992. Up to the fall of 1991, even though the province's intentions continued to fluctuate, an apparent change of attitude suggested that most of them would have no choice but to join the movement to harmonization started by Quebec and Saskatchewan. However, the NDP government elected in Saskatchewan in October of 1991 made it known that it was abandoning the harmonization plan. In April of 1991, Nova Scotia also indicated that it would not harmonize its sales tax with the Goods and Services Tax. After believing that harmonization would become a reality, Ottawa suddenly saw the climate deteriorate toward the late 1991. And until the end of 1993, there seemed to be little likelihood that the provincial and federal taxes would be harmonized. In June of 1992, the Supreme Court confirmed that the Goods and Services Tax was constitutional. During the 1993 election campaign, the Liberal Party of Canada, which then formed the official opposition, announced it will replace the Goods and Services Tax with a new tax. Once elected in November of that same year, it directed the House of Commons Standing Committee on Finance to consider alternatives to the Goods and Services Tax. On June 20th, 1994, the Finance Committee published its recommendations. In its report, it suggested that a value-added tax, or VAT, be introduced across the country, asserting that integration of the federal and provincial sales taxes was a solution to the problems caused by the existing Goods and Services Tax. In addition to simplify collection for small businesses through a business transfer tax, the committee's proposal would make it possible to integrate the federal and provincial tax systems completely. The National Value-Added Tax, or VAT, would thus have a federal component and a provincial component. It would ideally have applied to a single tax base across the country, except in Alberta, which had no provincial sales tax, and have a single set of standard rules. The committee believed at the time that the provinces would agree to harmonize their respective sales taxes with the proposed new national tax because of the benefits afforded by a national value-added tax, particularly a simplified tax system, reduced administrative and compliance costs, less bureaucracy as a result of the elimination of one complete order of government, and various economic benefits. The committee thus proposed a national value-added tax of 10%, with 40% of revenues going to the federal government and 60% to the provinces, and a standard tax on income of 1.25% to 1.5% to offset the shortfall in revenue. That August, the federal government proposed a value-added tax of 11%, in October, one of 12%, 5% for the federal government, 7% for the provinces, together with a standard 1% tax on disposable personal income and compensatory measures in the field of excise taxes. In each case, the proposal was for one national sales tax levied on the same base across the country, which would have been collected by the federal government. The provinces would no longer have had to spend the annual $300 million to collect the provincial sales tax. Businesses would have seen their compliance costs substantially reduced because they would no longer have to deal with two tax authorities. To avoid putting too great a strain on provincial revenue, the federal government planned to introduce sales tax credits for production inputs gradually over a period of 3 years to induce the provinces to harmonize their respective taxes with the goods and services tax. The federal government offered those that agreed to do so greater room to maneuver in the areas of personal and corporate income tax. The provinces rejected all these federal proposals. For some provinces, the loss of revenue following harmonization would be too great. In addition, harmonization would mean a transfer of the corporate tax burden to consumers, an idea generally opposed by the provinces. From October of 1994 until the end of 1995, there was no public movement on harmonization. Some believe that the election in Ontario in June 1995 of a Conservative government that had promised to harmonize the systems would be the catalyst for harmonized sales tax across Canada. However, in March of 1996, Ontario announced that the province had been unable to reach an agreement with the federal government. That same month, the federal government accepted the committee's recommendation on introduction of a national value-added tax. On April 23, 1996, the federal government announced that it had signed an agreement with Nova Scotia, New Brunswick, and Newfoundland and Labrador to harmonize those provinces' sales taxes with the goods and services tax. 6 months later, the parties signed detailed agreements under which a new harmonized sales tax of 15% would be introduced in the three provinces on April 1st, 1997. Under those agreements, the federal government undertook to pay $961 million over 4 years, being $349 million in each of the first 2 years, $175 million in the third year, and $88 million in the fourth year, to the three provinces to offset half of the loss in revenues caused by harmonization. To induce the provinces to adopt the harmonized sales tax at a rate of 15% in the Atlantic provinces and 14% elsewhere in Canada, the federal government had offered to pay such compensation if the loss in revenue exceeded 5%. This adjustment assistance was based on a formula that applied to all Canadian provinces and covered all of the differences for the first 2 years, 50% in the third year, and 25% in the fourth year. Under this formula, Quebec, Ontario, and British Columbia would not see their revenues from their respective sales taxes reduced by more than 5% under a harmonized system of 14% or 15%. As a result, they would not have been entitled to assistance if they had agreed to harmonization under the Letter of Understanding of April 23, 1996. Saskatchewan, Manitoba, and Prince Edward Island, on the other hand, would have been entitled to assistance, and if they had signed the Letter of Understanding, the federal government would have paid them $540 million for a total of $1.5 billion for Canada as a whole. The Western and Maritime provinces opposed the proposed compensation, deeming it unfair. Nevertheless, on March 26, 2009, in its annual budget, the province of Ontario announced its intention to merge its provincial sales tax with the goods and services tax to take effect on July 1st, 2010. Thus, on July 1st, 2010, the harmonized sales tax was implemented in the province of Ontario, as well as in British Columbia, despite public opinion polls showing that 82% of British Columbians and 74% of Ontarians opposed it before it was implemented. The implementation of the harmonized sales tax in Ontario and British Columbia replaced the separate goods and services tax and provincial sales tax charged on goods and services in those provinces. Nonetheless, the continued unpopularity of the harmonized sales tax in British Columbia resulted in the downfall of the government and a referendum being called to determine whether or not to maintain the harmonized sales tax in the province of British Columbia. As such, on August 26, 2011, the results of the referendum were revealed by Elections British Columbia, with 55% of 1.6 million voters favoring the abolition of the harmonized sales tax. The harmonized sales tax was abandoned on April 1st, 2013, and British Columbia reverted to a system with the goods and services tax and the provincial sales tax. Meanwhile, in Prince Edward Island, that government undertook to introduce the harmonized sales tax of 14%. This was introduced on April 18, 2012, and subsequently implemented on April 1st, 2013. In turn, what would happen is that we would have harmonized sales tax in 5 provinces. The 4 Atlantic provinces being Nova Scotia, New Brunswick, Prince Edward Island, and Newfoundland and Labrador, together with the province of Ontario. All the other provinces maintained and managed their own provincial sales tax system, with the exception of the province of Alberta, which to date has continued to avoid the necessity of implementing a provincial sales tax and therefore continues to operate with the government only on the goods and services tax, as well as the territories, given their relation to the federal government, which also only operates on the basis of the goods and services tax. And that is the history that we find to this date of the harmonized sales tax in Canada. Thank you.